I think all of us here really did not know some of the good things that Justice Abhay Oak has been doing all along. Thank you so much. Ladies and gentlemen, we now proceed to the next segment of today's evening, that is the inaugural lecture of Advocate Harun Solkar Memorial Lecture Series 2026. As you are all aware, the topic of which is Articles 19(1)(a) and Article 21, followed or forgotten. A strong legal tradition survives only when knowledge is shared, principles are tested, and generations learn from one another. Similarly, a strong judiciary is measured not just by its judgments, but by the courage, empathy, and the integrity of its judges. A beacon of judicial integrity and a tireless defender of constitutional values, whose courtroom was always a sanctuary of civil liberties and the rule of law. It is my absolute honor and privilege to invite Honorable Justice Abhay Oak to deliver the inaugural lecture of the Advocate Harun Solkar Memorial Lecture Series. Please join me in welcoming His Lordship with a round of applause.
Mr. Rafiq Dada, Mr. Shirish Gupte, Mr. Darius Khambata, Mr. Vishwajit Sawant, members of Solkar family, my esteemed colleagues, former colleagues in the Bombay High Court who are present here, senior members of the Appellate Side Bar, other senior advocates and members of the bar and law students. I consider myself to be lucky to be part of this function to felicitate Mr. Rafiq Dada. I have seen Mr. Solkar, late Mr. Harun Solkar, sitting in room number 18. I have seen him appearing before various courts, but I did not have much of personal acquaintance with him. But I have seen him arguing forcefully before benches dealing with criminal matters. Those were the days when we juniors were told to always sit in the court and not to stand in corridors. And therefore I had privilege of hearing so many cases conducted by Mr. Solkar. I know that Mr. Darius Khambata is going to speak on Mr. Rafiq Dada, but I want to briefly speak about Mr. Rafiq Dada. In 1995-96, he was Additional Solicitor General of India. It was a group of first appeals arising out of land acquisition references from Raigad district, where the issue was whether the persons in possession of salt works were the owners of the salt works. The trial court had held in favor of the salt work owners, and it was a group of about 1995 first appeals. And Mr. Rafiq Dada had told the bench headed by Justice Dudhat that he is going to take about 8 to 10 days because he had to devote a lot of time to argue on law and argue on facts in each case. I remember that late Bhausaheb Bobde was appearing for some of the claimants. Dr. D.Y. Chandrachud, as he then was appearing for other claimants, and I was representing about 27 claimants. I was 11 or 12 years into practice, and I knew that Mr. Dada is going to argue for 7 or 8 days. My matters were being called out in other courts. I was rushing to other courts. Mr. Bhausaheb Bobde, late Mr. Bhausaheb Bobde, saw that, and he told me at the end of the day, he said, please don't do this, because you will learn so much from the arguments of Mr. Rafiq Dada, so don't miss that. And please remember, Bhausaheb Bobde was opposing Mr. Dada. And I still remember the arguments of Mr. Dada. He started with history of land revenue laws in India. He told the court how revenue record evolved. He discussed 1879 Bombay Land Revenue Code, 1921 rules under the Bombay Land Revenue Code, and it was a treat to hear him. He submitted his written arguments, and since I used to appear in many salt matters, I had preserved those written arguments. But unfortunately, when I transited from here to Bangalore and Bangalore to Delhi, somehow I lost the copy of written arguments submitted by Mr. Dada. In 2018, when I was heading a division bench, again I had an opportunity to hear a great performance by Mr. Rafiq Dada. I think in 2017 an amendment was brought to Mumbai Municipal Corporation Act, which permitted municipal corporation to levy property tax on capital value. So he argued, I think, on behalf of Property Owners Association, where challenge was to the amendment and rules framed pursuant to that amendment. It was really a mesmerizing performance. I must say that we could not decide in his favor, but I remember his performance. There is one aspect of Mr. Rafiq Dada I don't think anybody will point out, therefore I want to point out. I believe bench headed by Justice Ajit Shah appointed a committee of lawyers, architects and eminent citizens of Bombay to monitor activities on Chowpatty, the beach. And Mr. Rafiq Dada was the chairman. And I must tell you, later on as a judge, I had occasion to deal with that litigation. I must tell you that it is only because of Mr. Rafiq Dada and his colleagues that we see relatively encroachment-free Chowpatty today. And I can't resist temptation of telling something which he did as chairman of the committee. I think in 2015 or 16, Government of Maharashtra applied to the committee because all permissions were required to be given by the committee. Government of Maharashtra applied to the committee for holding Make in India event, where they sought permission to construct a huge pandal, huge stage on the Chowpatty. Committee headed by Mr. Rafiq Dada wrote a long order and brilliantly written order giving reasons why such permission cannot be granted. It was challenged before me by Government of Maharashtra. I confirmed it. At production stage, Supreme Court granted interim order, permitted event to be held. Later on, due to a very unfortunate event, we realized that how right was Mr. Rafiq Dada, because after that huge pandal was erected, it was gutted with fire and it caused so much damage that entire sand on the beach was burned. And that was one of his reasoning in his order. I don't want to devote more time because Mr. Dada's Kampat is going to speak on Mr. Rafiq Dada. Today's topic is very interesting. Articles 19(1)(a) and 21, followed or forgotten. Of course, I am going to express my personal views on this, but most of these personal views will find place in my judgments. As all of us know that there are two important fundamental rights conferred on us by the Constitution. One is Article 21 and other is Article 19(1)(a). And we always say that freedom of speech and expression is one of the most fundamental rights. Of course, it is subject to Clause 2 of Article 19. You can't exercise your freedom of speech and expression by violating the law which is framed under Clause 2 of Article 19. Democracy will become meaningless if we do not have freedom of speech and expression. Under Article 21, everyone has the right to lead a dignified and meaningful life. The freedom of speech and expression under our Constitution is not confined only to written or spoken words. It extends to art, literature, drama, comedy, cinema, etc. And most importantly, it includes freedom to express opinions. In the absence of fundamental right under Article 19(1)(a), no one can lead a dignified and meaningful life, and that is how violation of Article 19(1)(a) always amounts to violation of Article 21. There is one more important provision of the Constitution which we have forgotten actually, and we have overlooked rather than forgotten. It is Article 51(a), which lays down fundamental duties of the citizens. Article 51(a) was brought on the Constitution by the infamous 42nd Amendment during the dark days of emergency, and that must be one of the reasons why we overlooked Article 51(a). In fact, if you go through Silvai's great commentary on constitutional law, 3rd edition, he has devoted only 15 to 16 lines to Article 51(a). If I am not wrong, Mr. Silvai says that it is not at all important because it is not a law. Later on, we realized that this Article 51(a) is so important, especially in view of 2 decisions of the Supreme Court, which held that the fundamental duty of the citizens becomes fundamental duty of the state. So all fundamental duties under Article 51(a) are the fundamental duties of the state, and naturally its instrumentalities and agencies of the state. And that is how 51(a) becomes very relevant. The first fundamental duty laid down in Article 51(a) is duty to abide by the Constitution and to respect the ideals under the Constitutions. All our laws are framed under the Constitution, and therefore it becomes collective duty of the state to abide by not only the Constitution but laws framed under the Constitution. There is second part of clause A of Article 51(a), the duty of citizens to respect the ideals under the Constitution. Now, what are the ideals under the Constitution? We will find in preamble. One of the ideals is secularism, other is democracy, and most importantly, liberty of thought and expression is also an ideal under the Constitution. And therefore, it becomes duty of the state to respect these ideals and the provisions of the Constitution, especially chapter on fundamental right. But in the present day, we rarely see government respecting the ideals under the Constitution. I have been a judge of 3 constitutional courts for a fairly long period of 21 years and 9 months. Based on my personal experience as a judge, I can candidly say that I have seen gross violation of freedom of speech and expression in our country. I can give hundreds of examples of gross violation, and it starts at grassroots level. 2 cases which I dealt with were referred by Mr. Vishwajit Sawant. I am going to elaborate on that. But about 12 or 13 years back, there was a case before me. It was by a teacher working in aided school in Maharashtra, in one of the taluka places. In that school, there was one rule that the morning session began by singing a particular prayer, and every student and teacher was supposed to stand with folded hands and sing that prayer. This teacher thought that it was religious prayer, and therefore he exercised his freedom of speech and expression and freedom of expressing thoughts. And he candidly told authorities that I do not believe in singing this prayer, and I cannot be compelled to join the prayer. Freedom of expression. He exercised his constitutional fundamental right under Article 19(1)(a). Disciplinary action was taken against the teacher, and that case came to the High Court, which I have to deal with. Another case which I want to refer is from Karnataka. When CAA came, people wanted to have a peaceful protest against CAA. Government of Karnataka never wanted even that peaceful protest, and therefore they promulgated an order under section 144 of CRPC for prohibiting that agitation. It was not an agitation, it was protest. And all that citizens wanted to have protests in the Freedom Park. Freedom Park is like Jantar Mantar in Delhi. But government prohibited it. Even that was carried to the court. One of the two cases referred by Vishwajit Sawant, one case was of a professor from Maharashtra. It was all about his WhatsApp status. He put on the WhatsApp status that 5th August should be celebrated as a black day for Jammu and Kashmir because that is the day on which Article 370 was abrogated. The second message wished Happy Independence Day to Pakistan. And there was third posting he made that he said that we are not happy with abolition or abrogation of Article 370. FIR was registered against him very promptly, alleging offence under section 153A. And what was the allegation? The allegation was WhatsApp status promoted disharmony, feelings of enmity, hatred or ill will between different religious groups. Another example which Mr. Sawant gave is of a political leader singing a poem on a video. And what was that poem? The meaning of that poem was, while fighting to secure our rights, if we are met with injustice, we'll face it with love. And there was a very strong statement in that poem. It said that if bodies of our loved ones are a threat to the rulers, we'll bury our loved ones happily. In fact, if you read the entire poem, it was a poem giving a strong message of non-violence. Still, this man was charged with very serious offences under section 196, 197, 299 and 302 of the Bharatiya Nyaya Sanhita. 196 and 197 are equivalent to 153A and 153B of IPC. And what was the allegation? Allegation against him was that he promoted enmity between religious groups. His imputations were prejudicial to the national interest, and he uttered words with deliberate intent to wound the religious feelings of many persons. These are only few examples, but what I learned from my experience as a judge is perhaps we have forgotten that tolerating divergent viewpoints is an essential part of democracy. Democracy is also one of the ideals and basic feature of our constitution. Tolerating thoughts which are contrary to the mainstream is a cardinal value which constitutes foundation of a democratic form of government. The manner in which law enforcing agencies target people who express thoughts which are against the popular sentiments shows that law enforcing machinery, like police machinery, is either ignorant about fundamental right under Article 19(1)A or does not care about it. And one of the main reasons is that they don't know their fundamental duty of upholding the Constitution and ideals under the Constitution. In fact, it is fundamental duty of every citizen, including the police and political leaders, to abide by the Constitution. And therefore, it is their duty to ensure that fundamental right of freedom of speech and expression and fundamental rights under Article 21 remain protected. As I have freedom of speech and expression, it is my duty to protect the same right available to the others. Even if others express thoughts which I do not like, I must uphold their right to express those thoughts. Unfortunately, neither political leaders nor law enforcing agencies are abiding by their duty to protect this important fundamental right. I have seen during last several years, last few years especially, that offences under section 153A and 153B of the Indian Penal Code and offences under section 196 and 197 of BSA are applied very casually, only because the views expressed by certain persons are not liked by others. A stand-up comedian makes a fun and says something. He is booked for offence under section 196 of Bharatiya Nyaya Sanhita. Again, the reason is the law enforcing agencies are ignorant about the basics of our constitution. Our police have always ignored, and even sadly some of the courts have always ignored, a very brilliant exposition of law by Justice Vivian Bose as a judge of the Nagpur High Court. And what he has said in 1946 before Constitution came into force. He was dealing with, a full bench of the Nagpur High Court was dealing with applicability of section 124A of the Indian Penal Code, offense of sedition. And he delivered majority judgment. And what he has said is very important, which is unfortunately not followed by many. Now what he says is, while deciding issue of applicability of section 124A, offense of sedition, what Justice Bose says is that while deciding the issue of applicability of section 124A, the spoken or written words must be judged from the standards of reasonable, broad-minded, firm and courageous men, and not those of weak and vacillating minds, nor of those who see danger in every hostile point of view. So therefore you can't apply offense of sedition or offense under section 153A or 196 of BSA only because the persons who see danger in every hostile point of view feel that they are offended. Now this is a test laid down. What is the effect of spoken and written words? Not on somebody who is very weak or not on somebody who sees danger in every hostile point of view, but effect on reasonable, broad-minded, firm and courageous men. This is the test laid down, and at least in 3 or 4 judgments of the Supreme Court, this test has been accepted. In fact, Supreme Court has applied this test even to offense under section 153A and 153B of the Indian Penal Code. But now we find that when the people in position are not able to tolerate the hostile point of view, they register offences under these provisions. As I said, police, we can't blame police if they don't apply the test laid down by Justice Vivian Bose, but sadly, some of the courts do not follow that test, which is binding on every court because Supreme Court has adopted that test. If we go into the history of freedom of speech and expression, when I go to law colleges and law schools, I always tell the young students to read defense speech or an address by Lokmanya Bal Gangadhar Tilak to jury, members of the jury in second sedition trial. It was in 1908. In fact, entire address to the jury is available on website. He says 2 things which are very interesting. Tilak says that only because few people feel that my writings are seditious, writings will not become seditious. Same test in different words, which was laid down later on by Justice Vivian Bose. And another important statement which he makes is that merely because British government does not like me, that will not entitle them to allege sedition against me. He uses the word, he says that I know that I am persona non grata of British government, but that does not mean that they can prosecute me under section 124A. Now this is said century back, even today it is very relevant when we decide the cases under section 153A, or now per se offense of sedition is not there in BSA, but it is in different form. Unfortunately, what he said in 1908 is required to be used today while defending criminal cases. Now we see intolerance to the thoughts which are not liked by the majority. Those who are in power do not tolerate criticism. I am not speaking about any particular political party, but this is the feature of our political system. We have forgotten that if we do not like a particular viewpoint, instead of attacking the person who expresses it, we must try to convince him by presenting our own point of view. Even if we feel that the views expressed are wrong, they should be patiently answered by adopting a thought process which we feel is right. Due to ever increasing intolerance, the freedom of speech and expression is under a threat. In democracy, which we adopted on 26th of January 1950, every citizen has a right to put forward his demands to the state and to the state machinery. His demands, his representation, that is his right. The state cannot ignore such demands or representation. It is the duty of the state to deal with every request, every representation, every expression of thought by a citizen of India. The government may or may not accept it, but it is the duty of the government to consider it. The government must have dialogue and discussion about any demand put forward by citizens. But perhaps with the passage of time, we have all forgotten these golden principles. And if demands are not considered, the citizens have a right to make a peaceful protest, because that is the only way of expressing displeasure. We always refer to the last address by Dr. Babasaheb Ambedkar to Constituent Assembly on 25th of November 1949, where he says that after Constitution has come into force, we should not adopt the means of protest like satyagraha, etc. But if you see the entire discussion in Constituent Assembly, nobody at that time imagined that the citizens' demands will be not considered by the government or by the state, or they will be ignored and there won't be any dialogue. Therefore, here comes the right of making peaceful protest within the constitutional means. And if we do not allow people to express displeasure by making peaceful protests, there won't be any democracy. There are citizens who are compelled to approach the courts, and in particular constitutional courts, on the ground that by registering an offence, their freedom of speech and expression is sought to be infringed. When such cases come before the court, it is the duty of the court to quash the offences. The court may not like what the petitioners have said or expressed, but still it is the duty of the court to protect the freedom of speech and expression. It is not the function of the court to preach or teach the petitioner what he should say and what he should not have said. That's not the function of the court at all. All that court has to see whether offense is made out and whether there is violation of fundamental right of freedom of speech and expression. And if court is satisfied that there is violation, court has to grant relief. Court is not concerned whether court likes what the person has said. Few days back, I read a speech rendered by my esteemed colleague in Supreme Court, Justice Ujjwal Bhutan, with whom I shared bench for a long time. He referred to a case decided by High Court. I don't know which is the High Court. It was a case where somebody wanted to hold protest, peaceful protest, to deprecate what has happened in some foreign country. Permission was denied by the police. The petitioners approached the court. The court told the petitioners that, look, why you are bothered about something happening in foreign country? You do something about what is happening in our India, in our country. And the court refused to grant permission. Now, court is not concerned with this aspect. Somebody wants to have peaceful protest without committing any offense. Police have to permit it. The protest may be on any ground. So long as it is a lawful protest within the constitutional framework, it is the duty of the courts to permit it. And since I am on this topic, because this was the case referred by my esteemed colleague Justice Ujjwal Bhuyan in his speech in Bhopal, I must read one sentence of judgment of our bench, which was written by Justice Bhuyan. That was in the case of Wikimedia Foundation versus ANI. Only one sentence I want to read. What Justice Bhuyan said in the course of his judgment. What he has said is, the courts must not be seen to regulate or stifle the freedom of speech and expression. It's very important. The courts must not be seen to regulate or stifle the freedom of speech and expression. This is very important message in the form of law laid down by the Supreme Court to all the courts. I always believe that the courts, and in particular constitutional courts, must be at the forefront to protect the fundamental rights of the citizens. In fact, it is the bounden duty of the courts to ensure that Constitution and ideals of the Constitution are not trampled upon. Endeavor of the courts should always be to protect and promote fundamental rights, including freedom of speech and expression, which is one of the most cherished rights a citizen can have in a liberal constitutional framework. As a matter of fact, the court must remain ever vigilant to thwart any attempt to undermine the Constitution and the constitutional values. The reason is that if courts are not going to protect these freedoms, these fundamental rights, who else is going to protect? Which institution is going to protect the fundamental rights of the citizens? So it is a bounden duty of the courts to do so. Now let us come to Article 21. Under Article 21, I am going to deal with issue of bail, which naturally has to be dealt with when I deal with Article 21. But under Article 21, we have right to live in pollution-free environment. And look at what is happening. Every day there is a breach of this fundamental right. This year, in 25-26, AQI of Bombay reached 300. So we want to compete with Delhi. Delhi has of course 400 and 500 from October to January. Now Bombay was saved only because of sea breeze. During last few years, we have systematically seen indiscriminate cutting of trees in the name of development, so-called development. And see what happens this year. In March and April, Bombay's temperature crossed 41, 42. We have never seen that happening. And why it is happening? Because we don't perform our fundamental duty of protecting and preserving environment, and we indulge in massive tree cutting in the name of development. A recent example which I want to share with you. The recent example is of court permitting cutting of 45,000 mangroves for one particular infrastructure project. Mangroves are not shrubs. If you go and see mangroves, they are fully grown trees, 10 years, 10 meters, having 10 meters height or 15 meters height. And they are the soldiers which protect the environment. All that activist said was, please appoint some expert agency. We don't want to come in the execution of the project. It was for coastal road. But let expert agency examine and find out whether some mangroves can be saved. Even this prayer was not granted by the court, which was being granted day in and day out in MC Mehta's case. When people used to come to Supreme Court, especially in Delhi Reach area, seeking permission to cut the trees. Now, this is happening pan-India. We had an example, it's a matter of record, that nobody was entitled to cut trees in Delhi Reach area without the permission of the Supreme Court in MC Mehta case. But we have classic example of Delhi government cutting more than 1,100 trees without permission of the court. 1,100 trees. And what we talk about, we say that all right, we are doing compensatory afforestation. Now if you are going to fell 50 years and 100 years old trees and you are going to make compensatory afforestation at a distance away from the place where original trees existed, how many years it will take to see those trees growing? So these are very disturbing aspects of violations of our right to live in pollution-free environment. This is happening in every city. Every city is losing green cover very rapidly. And therefore now we are facing the consequences. The climate change is one of the main reasons is this, that we are playing with the environment. And again, I say that it is a duty, fundamental duty of the state to protect and preserve environment. That's what Clause G of Article 51A says. But no government entity is bothered about this fundamental duty. And therefore, this leads to violation of Article 21. Now let us come to the bail. Now we have jurisprudence laid down by Justice Krishna here, that bail is the rule and jail is the exception. But today, unfortunately, we see that even in magistrate tribal cases, people have to reach Supreme Court for getting bail. There is a Najib's case, beautiful case, decided by beautiful judgment by bench of 3 judges. It's a very simple proposition that long incarceration cannot become punishment if trial is delayed. So if trial is inordinately delayed and there is long incarceration, notwithstanding all stringent provisions for grant of bail, person has to be released on bail. How many courts are following that verdict? There are 4 judgments of the Supreme Court, not 1, 4, which hold that the requirement of communicating grounds of arrest to the arrested accused under Article 22 is mandatory. Now some courts, some high courts are not following that, including our Bombay High Court. One of the other high courts other day said all these judgments are per inquirium. Now these judgments don't say anything more than what is said in Article 22. There is another peculiar trait which I have seen very recently while sitting in the Supreme Court. There are cases where people go to bail for getting bail in the High Court. One example I will give you. I have seen series of orders passed by one particular High Court where in regular criminal appeal against conviction, application was made for suspension of sentence and grant of bail. There were a series of orders passed granting bail, say for 1 year or 1.5 years, and liberty to renew the prayer again if appeal is not heard. There are cases where court comes to a conclusion, High Court comes to a conclusion that applicant is entitled to bail, but bail is granted for 6 months. In a later vein, I said in open court in Supreme Court that such orders benefit only one class, the class of lawyers. Where the moment this temporary bail expires, you have to go to a lawyer, lawyer will charge fees, so lawyers are the beneficiaries. But the principle of law is that if court comes to the conclusion that applicant before is entitled to bail, it is the duty of the court to release him on bail. Whatever conditions we want to impose, we impose. But why we have half-hearted measures like this temporary bail for 6 months or 1 year? And mind you, these orders were not passed on health ground or any other ground. Court recorded a finding that person is entitled to bail, but bail for limited period. Another example I will give you. There is a reported judgment, Delhi High Court stayed order granting bail. There was ex parte stay. There is a reported judgment of the Supreme Court which says that as a matter of rule, order granting bail should not be stayed. Only in rare and exceptional cases it should be stayed. Now we have a scenario where ex parte stay of order of bail is being granted by the courts, contrary to the law laid down by the Supreme Court, again following Article 21 of the Constitution of India. I can use several instances, kind of conditions which are imposed while granting bail. There was one condition imposed of dropping a pin on Google Maps as a condition for grant of bail, so that after a person is released on bail, police can track every movement of that accused. Of course, Supreme Court said that such conditions cannot be conditions of bail, but still we find, after Supreme Court has held that, we find such conditions imposed in the orders granting bail. Now, when we talk about these aspects, that is namely the violation of Article 21 and the violation of fundamental right of freedom of speech and expression, what is the solution? I think the only thing we can do today is to teach democratic values to our children in the schools and inculcate quality of tolerance in them. In fact, we must tell our children that they should stand up against every state action which violates fundamental rights, and the state must become more tolerant. And when it comes to freedom of speech and expression, I remember a quote which I read of Sir Thomas More, a famous poet and writer from Ireland. Now what Sir Thomas More says is very apt. He says that we must be bold enough to tell the king what he ought not to do and not what he wishes to hear. That's what he says. He has given a clear message about 150 years back, that we must be bold enough to tell the king what he ought not to do. The citizens are not expected to say only those things which are liked by the rulers. And therefore, if democracy is to survive, we must guard and protect our freedoms under Article 19(1)(a) and other fundamental rights along with Article 20 of the Constitution of India, even if we have to pay a huge cost for protecting these fundamental rights. I think I exceeded the time given to me, and I want to end by reading something from my own judgment that is very relevant as far as these two issues are concerned. what we have said, again sitting with Justice Ujjwal Bhuyan, what we have said is 75 years into our republic, we cannot be seen to be so shaky on our fundamentals that mere recital of a poem, or for that matter any form of art or entertainment such as stand-up comedy, can be alleged to lead to animosity or hatred amongst the different communities. Subscribing to such a view would stifle all legitimate expressions of view in the public domain, which is so fundamental to a free society. In fact, this is what I wanted to convey today on this topic. I again thank members of Solkar family for giving me this opportunity to participate in this function and express my views. Thank you.
Questions from the audience, please? Oh, we have one. Kindly assist with the mic.
Hello.
Yes. Yeah, hi sir. I'm the Grant from Hindustan Times. I just wanted to ask you, you talked about bail being the rule, right? So, Supreme Court has heard many petitions, many pleas filed by Umar Khalid. The trial has not yet begun in the case. There are several cases like Umar Khalid's, which are going on trial, does not commence, charges have not been framed, but they are languishing in jails. So what do you have to say about that?
See, we are talking about these individual cases. Law is absolutely settled. If there is long incarceration and there are no prospects of trial proceeding, bail has to be granted. And therefore, if somebody wants to criticize those orders, he will have justification in criticizing those orders.
So, those cases are also cases pending before the courts, right?
So they are pending now. I think Delhi High Court is hearing the bail application again.
Yeah.
That's what I read in newspapers.
Every time, even the Supreme Court doesn't hear the cases.
So let us hope that the settled law is followed by all the courts.
Sir, I'm Zohaib. I'm just a second year law student. It's a great honor to face you. I'm speechless. I really have nothing to say. My question to you is, sir, I have seen a lot of session courts are very reluctant, to grant bail, where they have all the provisions, they have everything written, but every alternate individual has to reach out to the higher authority like higher court or Supreme Court. How do you see that, sir?
I quite see what you are saying, but today is not a place to discuss the reasons why this is happening. There are many reasons why this happens, because I've seen judges who grant bail are being targeted at various levels. So it's a different subject where we need a lot of deliberations. I can't answer it here. I'm not saying that courts are justified in not granting bail, but there are reasons why this is happening.
Now I'm Advocate Qazi from Family Court. There is a different question from my side. I have been practicing as the Qazi of Bombay for the last, I'm 82 years now. I would like to ask one question. Why in the family courts and other courts, the Muslim personal law is not considered? Whenever there is a topic about the divorce or talaq, rajai or talaq, Bahina or talaq, Mughal Jillah, they say no. We have to go to the court to take the decree from the family court. It was not so earlier. Now because the people are Muslims are suffering for these questions. In case if they go to passport office, in case if they go to registrar of marriage office, they ask, you have to bring the court order, then only it is considered. My humble request to the Honorable Court is that why, when there is a personal law, when there are different laws are there, why it is not taken into consideration?
See, there are two things. If you say that passport authorities don't recognize the religious divorce in absence of order of the court, then that has to be challenged. This action has to be challenged. But look at from the point of view of the authorities. Now they need, if applicant is relying upon divorce, now they need some authentic material to come to the conclusion that there is a divorce. So if you say that erroneously authorities are not following, then it is a matter of challenge. But per se you can't find fault with the authorities when they say that we want order of the court. Now, for example, many cases it happens, if person is not being heard for 7 years or more. Now, if you go to a bank, bank will insist on degree of the court. So ultimately, we have to see the other viewpoint also, because some authorities have to act upon something, and they have to act in accordance with law. So it's a very complex issue.
Good evening, sir. My name is Rajendra Jadhav. I am first year LLM student from Mumbai University. Sir, you told in your speech regarding Article 51A, whatever duties are there of the citizens, the same duties to be there for the states also. My question is, sir, in our Maharashtra or in certain states, these Adivasi people where there are no roads for carrying the pregnant lady to the hospital, for that matter the poor children to the school, they are carried in a makeshift cradle or in some makeshift wooden piece to go to the school. So in spite of all the way 79 years of independence, the state is not providing or not recognizing the demands of the poor people. So what remedy would you like to suggest? Thank you, sir.
See, remedy is to go to read court. For it. This is a violation of right under Article 21. And of course, I mean, right to health is also now part of Article 21. These are the matters to be taken to the court. Because I think there was a PIL pending in Bombay High Court about the worst conditions of our primary health centers. I had occasion to pass number of orders that in primary health centers even basic medicines are not available. In some primary health centers, doctors are not available. So this is also violation of Article 21, which should be taken to the court. That there is no facility to carry somebody who is very sick to the hospital.
Good evening, sir. Sir, my name is Shabana Khan. I'm HM of a school. As you said, sir, कि schools में बच्चों को हमें inculcate करना होगा the constitutional values. But now today, sir, in Mumbai, Maharashtra, around 165 schools के ऊपर FIR हो चुकी है to close down. And close down to the schools who are unrecognized by the state of Maharashtra. Problem is that ये सारी schools slum schools में slum areas में चल रही है where fulfilling the norms are very much difficult. Now from past 3 years we are fighting this thing with the government, we are having conversations, but there is no kind of consideration to the slums area schools. Plus to that, अब FIR हो चुकी है, even the police is harassing to the HMs, to the secretaries, everyone, and now around more than 20 schools have gone to court. अब हमने writ petition भी डाला है और FIR के लिए quash भी किया है. My question is that, sir, कि when we have this history where this education has started from a very small hut, सावित्रीबाई फुले, महात्मा ज्योतिबा फुले and फातिमा शेख, ऐसे एरिया से हमने एजुकेशन को स्टार्ट किया है. आज स्लम्स की स्कूल्स को ये क्लोज डाउन किया जा रहा है और ये टर्म लेकर आर्टिकल 21 राइट टू एजुकेशन, उसी के अंदर पे सर हमें उसी धारा को लगाकर जो है हमें परेशान किया जा रहा है. सो इज दैट बीइंग एन एजुकेटर इन इंडिया इज अ क्राइम नाउ?
See, I tell you, these are very individual cases. There are schools in even city of Mumbai where students are enrolled but there are no teachers. So ultimately schools must have basic infrastructure. All this issue arises because we have wrong notions of development. And during last several years we have seen that government and local bodies like corporations, they are not setting up schools for the benefit of common man. So actually this is essential part of development, that the state must ensure that there are affordable facilities for taking education. Now that is not happening. So now education largely depends on private schools, and if private schools are not able to provide infrastructure, then these kinds of situations arise. So basically it is the duty of the state to ensure that public schools, in the sense that schools are set up by the government and municipal authorities, which will give a good quality education, but that is not happening.
Are there any questions from the audience on the top? Yeah. Please give your full name and your designation before you pose the question on the topic.
My name is Satish Bagade and I am a second year LLB student. Sir, माझा प्रश्न असा आहे की जेव्हा एक पॉलिटिकल पार्टी जेव्हा ज्युडिशरीमध्ये जाते तर त्यांची जी न्याय करण्याची जी काय बोलतात जी प्रोसेस आहे ही एकदम फास्ट रन होते. पण एक जेव्हा सर्वसामान्य व्यक्ती जेव्हा तो त्याच्या जस्टिससाठी ज्युडिशरीमध्ये जातो त्यावेळी त्याला प्रत्येक वेळी लॉंग प्रोसेसचा फेस करावा लागतो आणि या प्रोसेसमुळे लोकांचा ज्युडिशरीवर जो विश्वास आहे तो डे बाय डे कमी होतो. तर त्यामुळे आपल्याला ज्युडिशरीवर तो विश्वास परत मिळवण्यासाठी आणि प्रत्येकाचे राईट्स एक इक्वल आहे ते इवन पॉलिटिकल पार्टीसाठी असू या इंडिव्हिज्युअलसाठी असू तर त्यासाठी काय रेमेडीज आहे?
See, we can't say as a matter of rule that issues involving political issues or issues or the cases which are filed by political parties do not deserve priority. That's not the general rule. It all depends on subject matter of the case. I remember, I think in 2017 or 18, in one of the states, a government was formed which was alleged to be a minority government, and the governor granted time of 15 or 20 days to prove the majority. At that stage, Supreme Court immediately heard the matter and reduced that period to some 48 hours or 72 hours. Now, these are the cases where allegation was that the government doesn't have majority and you can't give them 15 or 20 days time to prove majority. Now, this case was heard out of turn. So, what is wrong with that? Ultimately, the courts have their own priorities, and these priorities become very important because we live in a system where we are not able to deal with so many cases. In Supreme Court now, pendency has reached 90,000. Go to any other democratic nation and find out how many cases are heard by topmost courts. You will find maximum 300, 400 or 500 cases are being heard by topmost court in other countries, whereas in Supreme Court, every bench deals with 250, 300 cases every week. And in the process, sometimes some people feel that priorities are not being properly followed. I mean, there may be some justification in that. But this issue has to be tested on broader perspective, looking into the total pendency of the cases in the court.
May we have the next question? Please raise your hand, whoever wishes to ask the question. Yes, ma'am.
I'm a journalist, Jyoti Purwati. I wanted to ask you that you said it's the duty of the courts to uphold the constitutional right. And you also gave examples when this has not been done. Now, when the Supreme Court itself doesn't uphold a constitutional right, then what are people supposed to do? What is the alternative? Used to be the last resort. If they are not upholding the right, then what are people supposed to do? I mean, as a judge, what would you say?
See, as I said, only the constitutional courts can uphold a fundamental right. There is nobody else. The political class is not going to do that. So that was my answer which I gave. The courts are the only institution where there is possibility that fundamental rights will be upheld.
Is there any other question from the audience? Yes, please go ahead.
Good evening, sir. Thank you for the wonderful lecture. I am Abhay from Government Law College. So you cited a case of the Allahabad.
Please be a little louder.
You cited a case from the Allahabad High Court, I believe it is Neeraj versus State of UP, in which certain judgments regarding the grounds of arrest were considered as infuriating. So, in your personal opinion, what would you suggest? What certain consciousness should be inculcated between the bar and the bench at an educational level, at a training level, so that judges and the bar continues to safeguard civil liberties? Thank you.
So, frankly speaking, I have not followed your question. I mean, you are talking about a view taken by Allahabad High Court that series of 4 or 5 judgments are per inquirium. Now, having better dialogue between bar and bench is not going to resolve such issues.
Sir, in your opinion, what consciousness should be inculcated at a training level so that judges take in view civil liberties while delivering such judgments?
See, if you talk about duty of the bar, then the first question which comes to my mind is how could a lawyer argue that 4 judgments of the Supreme Court of different strengths are per inquirium? Even lawyer could not have argued this. It's an imagination of the lawyer. So some responsibility has to be there with the members of the bar. I mean, Mr. Gupta gave example of Mr. Solkar. Now there are cases and cases where people deserve acquittal or people deserve bail, but they are strongly opposed on all possible grounds. So approach of the bar also has to change.
May we have the next question, please?
Good evening, sir. My name is Kavita Javeri. I am an LLB student from TC Law. We touched upon a very important subject this evening. Your kind self spoke about how the felling of trees is openly being done. My question as an environment conscious citizen and a law student is what can really be done to be taken, like damage control before it becomes excessive out of hands? Like, should it be a citizen-led movement? Should it be lawyers representing individual cases? If there is no political, will, let's say, to protect the environment, so should it be the judiciary? How should we broadly go about it, fragmenting it to lower levels and before the damage goes beyond perception?
See, I'll answer in 2 ways. Even the citizens are feeling their responsibility now. All these tree felling takes place on the basis of orders passed by tree authority of municipal corporation. Now, when application is made for felling of trees, notices are published. They are on website. Citizens are supposed to raise objections. How many citizens raise objections? Very few. So even citizens can do that. If in where you stay in that locality, number of trees are to be felled, you raise an objection. And one more thing which I want to point out, that see the plight of people who are raising environmental issues before the court. Nobody supports them. They don't expect any active support, but nobody wants to even praise them for taking up the environmental issues. On the contrary, they suffer at the hands of the state. So here there is failure of citizens also. The citizens are not doing what they are supposed to do.
May we have the next question, please? Yes.
Good evening, sir. My lord, sir, one question is a part of Article 9.
Kindly give your name and designation, please.
Sir, my name is Pawan Kumar Prasad, as advocate in Bombay City Civil Court and Foreigner Side High Court. My lords, in the freedom of speech, the 2 things, lordship. In the judiciary, एक दीपक चांद का सर कविता है. My lord's permission to say 2 lines.
But please ask the question.
Yes.
Don't express your opinion.
Yes.
You have freedom of speech and expression, but your freedom is only available to ask questions. Right.
My lords, the judiciary is the one part of oath of judge without arbitrary, with a fair in the justice. But sometimes the misuse the power of post and close the eye, assess the fraud degree without jurisdiction in the pending the matter. The lordship, this is the violation of Article 19 or a violation of Article 21 for the litigant, also the duty of Fundamental Right 51. This Deepak Chand का कविता my lord पे बता रहा हूँ. लक्ष्य भी तुम्हारा है.
I think we have said your question. Can we wait for the answer from the speaker?
Yes. All right, I'll answer the question. See, basically, you must remember one thing. I have said so on public platforms, even as a sitting judge, right from my Bombay High Court days, that every citizen has right to criticize, offer constructive criticisms of judgments of the court. It has to be constructive criticism. You can't generally say that, courts are not doing their duty or courts are committing mistakes. You study specific judgments of the court and then you are right to say how this judgment has gone wrong and where it has gone wrong. Making such general observations are not going to help the cause. A citizen has to stand and say that I have studied this judgment and this judgment is wrong for ABC reasons. So this can't be the approach that generally you say that courts are not doing this, courts are not doing that. This can't be the approach. And especially the approach of the member of the bar.
Can we have the last question from the audience, please?
Hello sir, myself Shubham Matre. I am 4th year law student from Magna School of Law. My question is very simple related to Article 19. Sir, my question is that as you mentioned about Jantar Mantar and protest, so what are your...
No, I did not mention Jantar Mantar. I did not mention Jantar Mantar. I referred to Jantar Mantar when I was referring to a particular place in Bangalore where protests are held.
Okay.
Freedom Park.
Right. That is related to freedom of speech and expression and Article 19. So I just want to know what are your personal views and opinion on this topic, like related to protest, Jantar Mantar, and also I want to ask you like what are your suggestion or advice to our generation like Gen Z related to Article 19?
See, my advice to younger generation is to read and understand the Constitution. That's the simplest advice I can give. And about right to protest, I have said everybody has right to protest, but in a peaceful manner. That right to protest is there, very much there, recognized by our Constitution, but it has to be in peaceful manner.
One last question.
Hello everyone.
One question.
One question. Hello.
Okay, may we have the last question, please? Please take the mic and be precise on your question, please.
Hello, my name is Akibat. I am LLM from University of Mumbai and I am practicing advocate. So my question is about the bulldozer justice. Despite laying down 14 key points from the Supreme Court regarding the bulldozer justice, some states and the municipal authorities are not following those key points. So what are the Supreme Court taking about the actions regarding this?
See, there is a law laid down by 2 or 3 judgments of the Supreme Court. If somebody is not following that law, ultimately citizens have to approach the court, High Court. Citizens can adopt the method of even filing contempt petition. See, there is a law. Now, unfortunately, that law is not followed by the authorities. Now, the only remedy is to go to the court and ensure that those judgments are implemented. But it's a stark reality that authorities don't follow the law laid down by the courts. So, remedies under the law have to be followed. Right?
My last question, please. May I request for a last question?
Okay. Yes.
Sir, my name is Advocate K.K. Sohane, and my question is the extension of Article 21, right to livelihood. Now the contemporary situation, now the contemporary situation, the AI is coming out, and there are companies who are giving, asking for mass termination. So, what measures as a contemporary situation would be, within the framework of the Article 21, can be done to save jobs, wherein by companies who force for mass termination, and even the banks, they give them a lot of fundings, but whereas comes to a small loan, even to give an advocate, they have been blacklisted.
See, first question. See, this has to be based on data. Are there instances where services have been terminated because AI tools are adopted by the company?
Sir, in the IT industry...
No, don't have these general statements. We have to study the cases where really it has happened. And only after we are satisfied that there are terminations which have taken place because companies have taken recourse to AI, then we can deal with this issue. These are all, general statements which are made without any foundation. And the last thing you should ask me, why banks are reluctant to grant loan to the lawyers. I was also sufferer in my practice days. But I will say only in one sentence, this shows that even members of the bar must introspect.